Time. Time is an important factor in our life. And time is so important that it takes place in our law also. And you know, law is the pillar of our society. There is a very close relationship between time and law. How time takes place in law? Suppose a businessman. It is not possible for a businessman to transact all his business affairs personally. He cannot personally attend to all his matters which are related to his business. He cannot create all the legal relationship with the parties who are related to this business. So, he has to depend upon a person to run his business affairs. And this situation creates agency. Today we will discuss a very interesting topic of Indian Contract Act 1872, agency. Before discussing the fact of agency, we must know who is an agent. Agent is a person employed to do an act for another or to represent another in dealing with third person. So agent is acting on behalf of another person. He is not acting for himself. He is acting on behalf of the another person. Now who is the another person? The another person is called the principal. So principal is a person for whom such act is done by the agent. The function of the agent is to bring the principal into contractual relations with the third person. This means that an agent is merely a connecting link. He is acting as a bridge between the principal and the third party. It is very important to note that what are the essentials of agency. First one is an agreement between the principal and the agent. Agreement. This is a very important term. Agreement, it is not the contract. Mind it, it is not the contract. There is an agreement between the principal and the agent. Agency depends on the agreement. You know what is the difference between the agreement and the contract? We have already known all the contracts are agreement, but all the agreements are not contract. Here it is the agreement, not the contract. Who may be an agent? Any person who is authorized to act as such may be an agent. An agent does not make any contract on his own behalf. It is not necessary that he should have a contractual capacity. Even a minor may be an agent because it is not the contract. It is an agreement. It is merely an agreement. So he may be a minor. But the principal and the third party must be competent to contract. If the person who is not competent to contract is appointed as an agent, what is the problem? The problem is that the principal is liable to the third party for the acts of the agent. So, in the interest of the principal, the agent should have the contractual capacity. The second essential is that intention of the agent to act on behalf of the principal. In case of creating the agency, the intention of the agent to act on behalf of the principal is a very essential ingredient. Now we will discuss what are the rules of agency. First one is whatever a person can do personally. Here the person means the principal. Whatever he can do personally, he can do through an agent. Of course, there are some exceptions. Exception is a marriage. If the principal wants to go to marry a lady, he cannot appoint an agent to go to that lady, to go there and marry that lady. It is not possible. So this is the exception of marriage. The second rule is that an agent's act and contract will have the same legal consequence as if the contract had been entered into by the principal in person. Suppose an agent, A is an agent. He receives certain amount of money from T. T is the third party, which is due to the principal, who is P. So here in this example, if T is giving the certain amount of money which he has lent from the principal, if he gives that amount of money to A, he is discharged from his obligation to pay that amount of money into P. The very important question, who can employ an agent? Any person who is of the age of majority according to the law, who is of sound mind, may employ an agent according to section 183. So, a lunatic, a minor, a drunken person cannot employ an agent. And all these characteristics are the who can employ an agent? Who is the capable person to employ an agent? Any person who is of the age of majority according to the law, who is of sound mind, may employ an agent according to section 183. So, a lunatic, a minor, a drunken person cannot employ an agent. All these are the characteristics of the competency of the contract. Any person who is competent to enter into the contract, he is competent to employ an agent. So, he must be sound mind, he must be a major, and he must not be a drunken person. According to section 185, it is said that there is no necessity to give the consideration amount of money to the agent at the time of appointment of the agency. So, no consideration is necessary to create an agency. Normally, an agent is remunerated by commission for the services rendered, but no consideration is necessary at the time of appointment. What is the difference between the agent and the servant? An agent is employed to create the legal relationship between the principal and the third party. And servant does not create any legal relationship between the employer and the third party. An agent is not the subject of the direct control and supervision of the principal. He has a large discretion. He can do anything. Under the authorization of the principal, he has a discretionary power. But a servant acts under the direct control and the supervision of the employer and is bound to follow the reasonable orders given to him in the course of his employment. An agent may work for several principals at the same time, but servant usually serves only one master. A principal is liable for the wrongs of his agent done within the scope of his authority, but a master is liable for the wrongs of his servant if committed in the course of his employment. Next, we will discuss another topic. Thank you. Stay safe and stay healthy.